What is arbitration and mediation in landlord-tenant disputes? Have you ever wondered how landlords and tenants resolve their disputes without heading to court? Today, we will discuss two effective methods, arbitration and mediation. These approaches are designed to help both parties find solutions while avoiding the stress and costs of traditional litigation. First, let's talk about mediation. Mediation is a voluntary process where a neutral mediator assists the landlord and tenant in communicating and negotiating. The goal is to reach a mutually acceptable agreement. The mediator does not make decisions but helps facilitate discussion. This method is often quicker and less expensive than going to court. It is especially useful when the tenant is reasonable and current on rent. Mediation can help resolve issues like lease disputes, maintenance problems, or disagreements about rent without escalating conflict. Now, let's move on to arbitration. Arbitration is a more formal process where a neutral arbitrator listens to both the landlord and tenant before making a binding decision. This means that both parties must agree to arbitration, either through a clause in the lease agreement or by mutual consent after a dispute arises. The arbitrator's decision is final and can be enforced in court if necessary. While arbitration is more structured than mediation, it is still generally faster and less costly than traditional court litigation. From a real estate investing and property management perspective, using mediation or arbitration has several benefits. These methods can significantly reduce legal costs and court delays. This helps landlords maintain steady cash flow and minimize vacancy periods. Additionally, these processes encourage cooperative problem solving, which can preserve landlord-tenant relationships. Resolving disputes quickly is vital for keeping rental properties operational and profitable. Mediation and arbitration also minimize the risk of retaliatory claims from tenants, as these processes are perceived as fair and neutral. They provide landlords with a structured yet flexible way to handle conflicts arising from lease terms, maintenance issues, or payment disputes. Incorporating mediation or arbitration clauses in lease agreements can prepare landlords for efficient dispute resolution. Landlords should also look into local programs or housing agencies that offer free or low-cost mediation services. This can make the process even more accessible. In summary, arbitration and mediation are effective tools for managing landlord-tenant disputes. They offer a balance between cost, speed, and fairness while protecting investment interests and tenant relations.